аспирантов нашей аспирантской школы, факультета права, и магистров наших магистерских программ по трудовому праву, и бакалавров, которые еще учатся на программе бакалавриата, и на самом деле просто всех желающих из других вузов, кому интересна та тема, по поводу которой мы сегодня собрались. А собрались мы сегодня, потому что у нас есть уникальная возможность послушать совершенно замечательного человека, который приехал на большую конференцию, которая у нас состоится завтра. Завтрашняя конференция будет посвящена взаимодействию экономики и трудового законодательства, трудового права. А сегодня вот наш ведущий эксперт на этой конференции, профессор Саймон Дикен, любезно согласился выступить перед нами. Позвольте мне немножечко вам его представить, хотя я уверена, что вы читали его биографию в объявлениях, которые мы публиковали о сегодняшней лекции. Саймон Дикен – профессор права Кембриджского университета. Он преподает трудовое право, корпоративное управление и частное право. Кроме того, он является директором Центра бизнес-исследований. Это междисциплинарная исследовательская группа на базе Кембриджской бизнес-школы. Он является автором ряда книг, в частности, «Право рынка труда», «Индустриализация, занятость и правовая эволюция», «Хедж-фонд активизм в Японии», «Пределы преимущественных прав акционеров» в соавторстве. Он публикуется в ряде ведущих юридических журналов мира, является главным редактором юридического журнала Industrial Law Journal и членом редакционного совета Cambridge Journal of Economics. Был приглашенным профессором в Колумбийском университете и является постоянным гостем в Институте Европейского университета и университета Дошиша в Японии. В 2005 году профессор Саймон Дикен получил стипендию Британской академии и удостоен звания почетного доктора Лувенского католического университета. Интересен, мне кажется, для нашей аудитории профессор Дикен тем, что он проводит исследования и преподает дисциплины на стыке права и экономики, в частности, трудового права и экономики. И у него есть некоторое такое преимущество перед нашим более узкодисциплинарным подходом, потому что позволяет более широко смотреть на правовые явления и в области трудового права, и в ряде других областей. И мы договорились, что сегодня он выступит перед нами с лекцией на тему «Введение в экономические основы права» на примере трудового права. То есть лекция будет посвящена и некоторым общим вопросам соотношения права и экономики, но в большей мере мы будем концентрироваться именно на примере трудового права. Значит, мы по формату договорились следующим образом. Профессор Дикен будет, у нас есть слайды, они переведены на русский язык. Те, кому нужен перевод на русский язык, синхронной устной речи, и вы еще, если не взяли наушники, пожалуйста, возьмите наушники. Кто хочет попрактиковать свой английский, пожалуйста, слушайте и говорите на английском. У нас будет обеспечиваться перевод, в том числе задаваемых вопросов. Мы договорились следующим образом. Он будет примерно 4, 5, 6 слайдов озвучивать, такие небольшие кусочки лекции, и после этого будет переходить к вопросам, то есть мы сможем задавать вопросы по ходу лекции, да? Не откладываем все вопросы на самый конец. По времени, мы не особенно ограничены временем, мы планируем, что лекция может занять где-то от 40 минут до часа, на самом деле это будет тоже зависеть от количества вопросов, которые будут задаваться по ходу. И дальше мы все совершенно свободны в том, чтобы задать любое количество вопросов. Профессор Дикен очень благоприятно настроен на то, чтобы с нами обсуждать все темы, которые нас интересуют. И в том числе мы договорились, что если вас интересуют какие-то вопросы из области права Великобритании, то эти вопросы тоже можно задавать. Ну и вот на этом позвольте мне тогда остановиться с кратким введением и передать слово профессору Кембриджского университета Саймону Дикену. Саймон, you are welcome.
Thank you very much indeed. I'm very grateful to the Higher School of Economics and to Professor Gerasimova for inviting me to give this talk this evening. Thank you very much to all of you for coming. And the topic of my talk is the economics of law in general and the case of labour law in particular. What I'm going to do is to begin by saying something in general about the economic approach to law and why that is interesting for lawyers. I guess most of us here this evening are lawyers. Maybe there are some social scientists as well. But I think maybe I have to first of all convince you that law and economics is an interesting approach to studying law. And then I want to look at the way in which economists and other social scientists have addressed the question of labour law. And I want to explore some questions about the function and nature and effects of labour laws. And I want to address some very critical policy questions about the way labour laws work. Because for economists and others, labour law is a controversial field. Right? It's very controversial because the economic effects of labour laws are disputed. Right? Are labour laws good or bad for the economy, for wealth and for growth? Do labour laws confer protection on workers at the expense of the competitiveness of enterprises and at the expense of economic growth? Right, that's a huge question. It's a really big question for labour lawyers to face today. I guess a related question would be, how is labour law adjusting to changes in the nature of work? The gig economy, Uber, big case about that in London last week. Is Uber an employer? Are its drivers workers? Well, yes, said one employment court in London last week. That's not the end of the story. But can labour law adjust to a world of fragmented capital? Can labour law adjust to a world of robotisation or digitalisation? All these are really big issues for labour lawyers, seems to me. But our training as labour lawyers does not necessarily equip us to answer these questions. Right? As lawyers, we're trained to interpret texts and understand procedures and explore concepts. We don't always receive training in sociology, in economics, or in the practical nature of the way in which businesses work. But we have to move a little bit beyond our core training to understand the effects of labour law. We can study the meaning of legal texts, but it's a different story to understand how labour law interacts with the labour market, how it interacts with the enterprise. Now there, we increasingly do need to take an interdisciplinary approach, I think. So I'm a lawyer, like nearly all of you. I'm not an economist, but I'm interested in economics. Right. And in Cambridge, I work with economists and sociologists who are interested in law. Right. So this evening, I'm going to set off on a journey of exploration into economics to try to understand what they are saying about labour law. And I also want to present to you some evidence which we have been collating in Cambridge, evidence on labour laws around the world, a big data set that we've been creating of labour laws. And I want to explain to you how we use those data to examine empirically some of the claims around labour law. The claim that labour law causes unemployment, or the claim that labour law slows down growth. We can study these issues empirically, but we need to get the evidence first. So what I want to do is set out on this journey, and hope you'll come with me. Maybe much of this would be new if you've only so far studied labour law at bachelor's or master's level, or possibly not. Maybe you're already familiar with many of these arguments. But if something I have said is not at all clear, I'm very happy to stop and explain it again. And at various intervals during our talk and session this evening, I intend to pause and stop and invite observations and questions. If I'm not stopped, I'll just carry on talking for about 30 or 40 minutes in the first place, or until I run out of breath. Right, okay, thank you very much. So let me begin by just referring to some of the policy perspectives on labour law which have dominated the debate. This is where we begin, a debate about whether labour law is good or bad, very simply. From a labour lawyer's perspective, labour law is the law, I would say, which protects workers in a position of wage dependence or subordination, as we lawyers tend to put it, a situation where the worker, because of his or her subjection to the command of the employer, is exposed to particular physical risks, economic risks, psychological risks, and labour law, as an area of law, intervenes in the employment relationship to provide basic legal protections against the power of the employer, protections which offset the risks which workers face in a market economy. In a free market economy, in a capitalist economy, workers sell their labour power to the employer. They don't have direct access to the means of production. They are exposed to risks of unemployment, illness, sickness, old age, interruption to work, which are particular to the way a market functions. So I personally think that labour law as a discipline is the law of the labour market. We see labour law in systems which are market economies. Every market economy has labour law. Why is that? Because labour law is needed to coordinate resources in a market setting and to deal with the risks which are particular to a world with a labour market, one where capital hires labour, not the other way round. That's my feeling. Labour law is universal in a market economy, but labour law is controversial. The aim of the International Labour Organization, historically, was to ensure that there could be agreement between countries on basic labour standards, so that international trade would not take place on the basis of a race to the bottom, a race to always cut costs, always cut wages, always sacrifice workers' welfare. The International Labour Organization has as its goal the International Labour Code, which exemplifies the principle of agreement between states on core labour standards in relation to wages, working time, dismissal, and freedom of association and the right to strike. Agreement on these core conventions is the objective of the ILO. That's reflected in the Declaration of Philadelphia of 1944 and in the ILO's Declaration of Fundamental Principles and Rights at Work in 1998. So the assumption here is that we need labour law to make a market economy function globally and nationally. We need labour law to facilitate and encourage international trade. Otherwise, states won't trade with each other. If states fear being undercut by labour standards which are inferior in states with which they trade, there'll be less trade. Similarly, within a country, if enterprises fear undercutting from rivals who, for example, will not observe the minimum wage or do not observe working time laws, employers are deterred from implementing better paying conditions. So that's a theory of labour law. But from the 1980s onwards, increasingly this theory is questioned, and it's questioned globally. So by the time we get to the 2000s, the World Bank, for example, says laws created to protect workers often hurt them. Right. So here's the idea that labour laws are harmful for workers. Why is that? Labour laws artificially raise the cost of labour. They insert standards into the employment contract which would not have been agreed between the parties. They distort the workings of the labour market. They prevent supply and demand from coming into equilibrium naturally. They cause unemployment, and they slow down the rate of innovation and growth. And this is bad for the economy, but it's bad for workers too, because the effect of providing some workers with protection is to cause others to be unemployed, because they can no longer access jobs. So the World Bank, in its Doing Business report in 2008, is very clearly putting this critique of labour law. And the World Bank's mission is very much not the mission of the ILO. The ILO's mission is to create international consensus on labour standards. The World Bank's mission is to create an international consensus on the need for countries to create a good environment for business. Right. The World Bank measures the ease with which companies can do business in different countries around the world. And labour law, according to the World Bank, is not conducive to doing business well. Right. So here there's a very clear bipolar clash of views, of opinions. I should say that the World Bank has more recently changed its view, and I want to explore this in a bit more detail in a few minutes. Many economists now would say there's nothing wrong with regulation as such, but we need to get the level of protection right. So the World Bank in 2015 did change its position. It said there can be too little labour protection as well as too much. So this debate is continuing, but there's still nevertheless a very clear difference of opinion between organisations like the ILO and those like the World Bank. Now, if we think about these questions, does labour law really have these effects? What impact does it have upon the firm? Does it really have the consequence of causing harm to workers? We as lawyers have difficulty answering those questions, as I've said. We need some help. We need to model the way that the laws affect enterprises and the market, and we need to study this question not legally, not through the interpretation of texts, but we need to study it empirically. However, I think as lawyers, our skills are needed, our knowledge is needed in order to answer these questions, alongside the knowledge and skills of the economists, because we are trained in understanding not just the texts, the concepts, the principles of a legal discipline, but also the operation of courts, the operation of legal institutions, of labour inspectors, in ways which are important for getting a fully rounded view of these issues. So my view is not hand over the question completely to the economists. This should be a joint effort between lawyers and economists. But one puzzling thing many lawyers find, I found it when I started studying the economics of law, is there's a really big difference in methodology between economists and lawyers. And we need to remember this. We as lawyers are trained to interpret texts, to arrive at systematic, coherent, agreed upon meanings to legal institutions and concepts. Much of our work involves retrieving texts, trying to make them fit together, trying to construct an organised whole out of lots of individual disparate parts. I think lawyers are good at putting things together. Right? I think economists often take the very opposite approach. Right? They want to take things apart. I mean by that they want to reduce a complex reality to something a bit simpler. Economists like modelling, and of course they also like mathematics. I'm not going to show too much maths this evening, because I know we're all lawyers, and maybe you became a lawyer because you didn't like doing too much maths. Lots of people say this to me, especially when I teach the economics of law. So I didn't become a lawyer to do maths. Right, okay, but some little maths might be okay. Sure. These days, you can't be an economist without being really good at maths. Okay. But maths is like anything else, and statistics can be learned, even by lawyers. So there's nothing to stop us learning about economic modelling and statistics. Okay. But their approach is to break things down, not to build them up, at least initially, to reduce a very complex reality to a model, a series of equations, and a series of relationships which can be understood statistically and which can be measured. If something cannot be measured for an economist, or let's be honest, for all scientists, right, for all scientists who do natural sciences and social sciences, if something can't be measured, maybe we can't say too much about it. For us lawyers, that's not a problem. We can understand the world without measuring it. We have different techniques. Okay, but economists need to measure the world, and to do that, they need to reduce it to a model. Now, models are very often not realistic. Right? Now, people say to me, what's the point of using a model that's not a realistic model? Right? One assumption which economists tend to make is that individuals act rationally when they're taking market decisions. This is a so-called rational actor assumption. And they also assume that very often markets self-adjust, that they come into equilibrium naturally if they're not interfered with. And lawyers say to me, why should we assume such unrealistic things? Why should we assume that people are rational? Very often people are irrational, and very often markets don't clear. Now that may be true, but economists tend to answer that a model doesn't need to be realistic, because it is, after all, a model and not the world. It's a reduced form of the world, and the point is this: the point of the model is not to describe the world. It's not to describe the world. The point of the model is to generate a hypothesis about the world, a question or a claim about the world. That's the point of the model. The model needs to be simple to do this. But the model isn't true. The model is just setting up a hypothesis, which is then to be tested. So, you may, as an economist, believe in neoclassical economics. It's not the only school of thought, but a neoclassical economist would say workers and employers are rational agents, and they will decide how much labour to sell or labour to buy, depending on the price stated in the market. They will trade off, if they're workers, leisure against wages, and if they're employers, they will employ workers up to the point where it is no longer economically feasible to do so. So the marginal worker, the last worker to be employed, after that, the employer won't employ anybody more if the cost of doing so exceeds the expected benefits. Both sides act rationally in this setting. And you may say, well, in reality, there may be customary wages or collective agreements or expectations which form the basis for contracting which are not captured by this model. But the point about the model is it predicts something very clear. It predicts that if you interfere with free bargaining between individuals and employers, if you interfere with that by setting a legal wage, not an agreed contractual wage, you are upsetting the process of free negotiation, you are interfering with the forces of supply and demand, and they will not equilibrate, they will not adjust, and the market will not clear. So this model predicts that if the market is working otherwise perfectly, a minimum wage will distort market outcomes because it will interfere with freedom of contract, and it will lead to involuntary unemployment. Some people will be unemployed who would like to get jobs, but they can't get jobs because their labour is worth less than the minimum wage. So no employer will employ them. Now, we may query this claim. That's my point. We may investigate the claim, but the theory of the perfect labour market generates a hypothesis. The minimum wage causes unemployment. We then set out to test it. That's what I mean by economic method. But we must remember as lawyers, at least this is my understanding, the economists are not saying that the model is true. They're just saying it generates a good question for us to pose and answer in a particular way. And social scientists would say, we make progress when we set good questions for empirical analysis. That's the point of model building, that's the point of theory-driven economic and social science research. Now, so what does neoclassical theory say? Neoclassical theory says agents have full rationality, they decide rationally, they can predict the future, they're endowed with the capacity to act in an instrumental way. Right. They also say the market self-adjusts. If you leave the market alone, it'll come into an equilibrium where supply meets demand. At that point, all resources in society have been perfectly allocated through the price system. The price allocates resources to uses. And the price system does this through the invisible hand, as Adam Smith put it, without the need for the state to intervene. If the state intervenes, then the result is negative in terms of efficiency, because resources are no longer being efficiently allocated to the correct uses. So an economist, when they talk about efficiency, they mean, are the resources available to society being well used? Are workers being employed in the right jobs? Is production of wheat at the right level compared to steel? And so on and so on and so on. That's what they mean by efficiency. And efficiency is measured by the sum total of how far all individuals' preferences are met through market-based exchange. So anytime you interfere with the market, you're not just producing a distorted outcome, you're also making people worse off in the aggregate. You're reducing the wealth of society if you interfere with the market in an illegitimate way. So in that sense, labour law, if it had the effects claimed for it, would be restricting economic growth. If labour law distorts market outcomes, there's less wealth in the economy, firms will grow less quickly, they'll be less profitable, and the economy overall will grow less successfully. So this is a notion that many neoclassical economists still have, and neoclassical economics is still the dominant economic theory of our time, still very important, although it is changing. It's changing very slowly. I'll explain how later. What does a trade union do? The trade union is essentially a club or group of workers. They band together, they collectively negotiate with the employer, and they insist that the employer respects the going wage for that job or that trade. So the union functions a bit like the minimum wage, except through concerted worker action. According to some economists or lawyer economists, when the union does this, the union is acting like a cartel. The union controls the labour supply, so just like a group of oil companies or OPEC control the oil supply, so workers control the labour supply, they push up the price of labour. In the same way that we might question this through competition law or antitrust law, we might want to question collective bargaining in labour law for exactly the same reasons. Another set of economic arguments take a macro level. Now, when I say micro, I mean the individual relationship between the employer and the employee, but the kind of macro level is the whole economy. And at the macro level, lots of forces interact to affect the overall level of output and the dynamic growth path of an economy. Now, many economists argue that granting workers statutory rights artificially raises the rate of inflation, which is consistent with low unemployment. This is a so-called natural unemployment rate theory. Milton Friedman developed this. He argued that if you raise the price of labour artificially, you need a higher rate of unemployment to control inflation. It's a slightly technical argument, but inflation goes up, you need more unemployment to reduce inflation. So if you're artificially causing inflation to rise through labour law, you need more unemployment to deal with it. And this theory is still really important. It has evolved since Milton Friedman's day to include rational expectations theory and all sorts of other more complex theories. But many central banks still follow something like this idea. They want to keep inflation low in order to keep unemployment low. And the way they do this is to promote labour market flexibility. flexible labour markets for central banks are a really important way of controlling the macro economy. Now that, of course, also puts a question mark over labour law, because a central bank is thinking too much labour protection equates to a very negative situation for the macro economy. Now, these are not the only economic theories which apply to the labour market, I should say. So, what are the other theories? A body of work which is sometimes called new institutional theory, which may be about 30 or 40 years old, questions neoclassical economics by saying, okay, we know your models are not realistic, we know they're not meant to be, but actually they would be better models if they were a bit less unrealistic. Right, okay, we know a model is not a description of the world, but using a model which is clearly wrong will not really help. Okay, is it true that people behave with complete rationality, that we can see the future, that we never make any mistakes, that we always maximize our well-being, that we always trade off these things well? Maybe not. An institutional economist would say, we have bounded rationality, we have limited rationality. We can't foresee the future, we're not computing machines. Our human nature may make us behave in certain ways which are not strictly rational. This is a field now known as behavioral law and economics. Behavioral economists say that often people have what they call a less than rational preference for equality. Or they say, we have a preference for being social. And some economists believe we get these preferences from our human nature. Other people think they learn them. Well, here we are this evening, we're being very social. Right. Here we are in a big group having a seminar, and we're exhibiting what behavioral economists call prosociality. Right. Human beings like to get together. And you may not believe this, but actually human beings are really good at cooperating. I know, you might think it's unlikely to argue that we have an innate tendency to cooperate with each other. But compared to most animal species, it seems we do. Human beings are very cooperative compared to virtually any other animal species, except for the ants. They're also very cooperative, of course. But they have a slightly different mode of social organization and genetic structure too. Maybe it's true. We don't act as computing machines. We don't act purely instrumentally. Maybe we like some equality, actually. We have a preference for it. Maybe we can't tolerate too much inequality. Who knows exactly why? But we do know that we can't foresee the future. We do know that we need more than just the price system to arrive at effective coordination in modern complex economies where most trade goes on between strangers. So this is the idea that markets aren't normally perfect. If markets are perfect, a legal interference with the market will cause bad results. Of course it will. That follows axiomatically. But maybe labour markets are affected by fundamental imperfections. So let's just think about what some of those might be. Employer monopsony. This is quite an old idea. Employers have power. And employers have power to depress wages below a market clearing wage. Right. So the employer, or maybe a group of employers, are the opposite of the cartel the unions form. The employer can get away with paying wages below the market clearing rate because employers need workers. Workers need employers, get it the right way round, more than employers need workers. Right. Employers have power because the employer is capital. The worker has no access to capital, has no access to the means of production, must sell their labour to live. Adam Smith said this in the 18th century in The Wealth of Nations. The employer can hold out against a strike much better than the worker can hold out against an employer. And it could be that workers have limited mobility. Right. We are people. We are not just units of exchange. Right. We cannot just move to the next town, the next country, the next city to get a job. The labour market is less than perfectly mobile. Now, okay, maybe you can make it more mobile these days it's much more mobile than it was. Right? It's mobile internationally and nationally to a much greater extent. But we're not perfectly fungible units of exchange. We're human beings with social ties, with families. We can't just get up and leave for the next job opportunity. Employers have power. Employers have information. Right? Employers have more information on the whole than workers do. And economists call this asymmetric information. And asymmetric information stops the market working perfectly. In itself, before the state intervenes, asymmetric information causes blockages or obstructions to the price system working properly. Indeed, we need institutions beyond the price system to make prices publicly known. We need the legal system, I think, to even disseminate prices very often. And in the models normally used by economists to describe the perfect market are models of the stock exchange. This is the original Walrasian 19th century model of the perfect market. Walras, the French economist, based his model of perfect competition on the stock exchange, on the bourse. And Walras said, in real life, my markets won't work perfectly unless we assume that there's something which makes prices publicly known, not just privately known, publicly known. And he says, I will assume there is an auctioneer or a crieur. I'll assume, for the sake of my model, there's something that makes the prices public. Right? Otherwise, even these neoclassical models don't work without this. The crieur in 19th century France, and this is just an example of what I mean by how important law might be to economics. The crieur was a public legal institution in the stock exchange. It's in the Code de Commerce. The crieur's job publicly is to announce the prices of the shares. So even the most fundamental ideas, which economists think are natural, quite often have a legal or institutional foundation. That's very interesting. Now, the labour market, even more so. Wages are disseminated, often by collective bargaining, often by the state through the legal system, through collective wages awards. Overcoming some of the information asymmetries is critical. A role for the state emerges when the market is less than perfect. Now, a problem with this body of work, it seems to me, is it says we might need the legal system to make the market work better, but we don't have a good grasp of how much of it we need or what exactly we need it to do. That's my final bullet point here. It's not clear what the exact right level of regulation would be from this theory. So this new institutional theory kind of says, well, we may need the legal system, but we can't say exactly how much law we need or what sort. We can't calibrate these legal effects so clearly. And so many economists say, yes, we understand about the limits of perfect market theory, but are you sure you would be making the market work better if you intervened legally? You might make it work worse. You can't guarantee this. And I think that's quite a good critique, actually. Now, a third body of theories, I'm still on theory, okay, what I call systemic approaches. Right. Now, this body of work doesn't think of labour law as a perfect solution to labour market imperfections, but it sees labour law as evolving alongside the market economy in a kind of experimental trial and error way. So the labour law system and the industrial relations system co-evolve and present each other with problems. Right? Labour law responds in practice imperfectly to problems of coordination, problems of risk management, often before the state itself intervenes. So collective bargaining begins with workers grouping together to try to set a collective wage. Social insurance begins with small towns and cities organising mutual relief systems to deal with unemployment and sickness. Now, later on, the state may take these experiments in collective action and make them work. But regulation isn't perfect either. Regulation isn't perfect, and the market isn't perfect. But it's very hard to envisage a market without some form of regulation. Part of my research is historical, and I've tried to show how for European countries, particularly my own, Britain, there never was a time historically when the labour market wasn't regulated somehow. The idea that there was a golden age in the 19th century of laissez-faire, when there were no legal rules about the labour market, is wrong. It is a myth. There were rules about the labour market as long ago as the early modern period in Britain, after the end of the medieval period, the end of access to the land by the working population, the Protestant Reformation, which removed the role the Catholic Church played in providing some form of social safety net, and replaced it with what? With what we call the poor law, early social security law, dealing with the consequences of a labour market. You can see that in England as early as the 16th century, and in other European countries too. Industrialisation did not just happen because all the rules were removed, as Adam Smith appeared to imply. There were other rules which were retained. Now, if we look in detail at the evolution of labour law in any country we care to consider, and this will also be true of Russia, we would see very complex co-evolution of legal rules with the emergence of markets. There wasn't a stage when the market was fully formed before labour law came along. Now, this, I think, is a more indeterminate, messy way of thinking about labour law. It's difficult to mathematise this. It's not a perfect model. Some economists would mathematise it. Complex, dynamic, evolutionary equations can be used. You could do this. I won't do that now. It could be mathematically modelled in a dynamic, evolutionary way. But the point I want to make is, if you see labour law this way, you see it as part of a market economy, not separate from it. And that's, I think, more accurate than the neoclassical approach. So far, so good. Just a couple more slides, and I'm going to stop for a pause. But let's think about the way labour lawyers themselves describe the contract of employment. In many European countries, possibly in Russia, I'm not exactly sure, the terminology of subordination is used to describe the relationship between the employer and the worker. And labour law, in talking about subordination, accepts that the employer has an inherent power to give orders to the worker, to coordinate work within the workplace. And this power, we sometimes call it managerial prerogative, is recognised by law. And historically, many countries saw employment as service, very close to being more like slavery or serfdom. There's been an evolution away from unfree labour to free labour. Slavery, serfdom, have been displaced by other forms of work. We say the contract of employment is based upon free labour. All of us choose to work, although if we don't work, we may find that we starve. That's the reality of being in a market economy with a weak social safety net. But of course, formally, we choose to work for somebody else. We're not directed to work for them. I won't talk about this much now, but interestingly, in a socialist economy, there's no choice about where you work. You're directed to work, and probably no wage either. So China, before 1986, the Soviet Union, these were not, I think, capitalist economies. I think that's misdescribing them. They were not authoritarian capitalists. They were something else, genuinely different. They were. In a market economy, you're free to sell your labour power or not. But if you do sell your labour power, you're at the disposal of the employer. In return, the worker acquires certain basic social rights. It is a kind of big bargain that's going on. The worker is at the employer's disposal. The firm, not the worker, the enterprise, keeps the residual from production. That's capitalism. That's how it works. A value is created through the employment contract, which is not the workers. It belongs to the shareholders in the firm. Absolutely it does. It belongs to capital, not labour. But in return, labour gets some social guarantees, some protection of health and safety. The first labour laws were health and safety laws in the modern period. The Factory Acts in the British Industrial Revolution, child labour laws, restricting employment for people by reference to age. Later, we have social security, taxation, a whole set of institutions which accepts the fundamental inequality within the employment contract. The employer has power over the worker, but in return, workers get some social guarantees against labour market risks. And the contract of employment, juridically, we labour lawyers say, is a cornerstone of this system because it simultaneously describes the employer's power and the worker's rights. This is the cornerstone of labour law, which may or may not survive Uber. We shall see. Okay, but maybe Uber is an employer. Okay, right. But this is the model we use. This is our model. Right. Now, if you think about the way an economist would think about that, a great institutional economist, Ronald Coase, and the founder of the economics of law discipline, wrote his first paper about the theory of the firm. And he said, contractual relationships within the firm are different from contractual relationships outside the firm. Inside the firm, the employer has power. He does not have to renegotiate every minute of every day what the worker has to do. But the employment contract is very, very vague about what the worker must do in return to earn their wages. The employment contract is incomplete, but it contains this residual power. Why is that power important? It's important because it's efficient to save on the transaction costs of repeated negotiation between employer and worker by putting in place a different type of contract, one where the employer has power to give orders to the employee without needing to renegotiate the way the work is done hour by hour, minute by minute. So Coase's explanation for the employment contract was not the same as Marx. Okay? Marx said this is exploitation. Coase says it's efficient. Right? It works. It produces a social surplus from which both sides benefit. Right? And this, I think, is a very significant idea. The theory of the firm in economics, Coase, Alkian, and Oliver Hart, he's the person who was awarded the Nobel Prize in economics last month, a month ago today. Oliver Hart became the Nobel Prize winner for economic science for his work on contract theory. This is another branch of a body of work which tries to explain how the firm works from an economic point of view. Now, it seems to me that if you talk about the firm this way, lawyers recognize straight away what's meant. Right? Sometimes law and economics intersect. Coase, in his famous article, refers to legal texts. In fact, he says, my theory must be true. This is great, I think. He says, it must be true because the lawyers say so. Right, okay, well, okay. That may or may not be a good reason for believing it is true. Okay, but sometimes law and economics do intersect. Now, I think, therefore, this is just one example of how institutional economics helps us understand our own subject, our own legal discipline. It's saying to us that labour law is in some way functional. It does a job. It assists the reduction of transaction costs. It assists coordination within the firm by allocating residual power to the employer. But of course, labour law does much more than that. Labour law also encourages the production of skilled labour. Labour law encourages investment by the employer and also the worker in human capital. In a sense, maybe labour law assists the creation of the commodity labour power which is exchanged within the employment contract. Labour law performs all these very interesting economic functions which we never really think about as lawyers, but which from an economic point of view make, I think, complete sense. Right. Okay, so I've been going for almost an hour, so it's definitely time to stop. Right, so I'm going to pause before I go on to talk about empirical research and invite questions or observations on what I've been saying Of course, if you don't have any questions, that's fine, but I'll pause anyway, because I'm running out of breath. So I invite questions. Thanks very much. Thank you. In English, yeah.
I have a question about
Свет, микрофон. Пожалуйста, когда вы будете задавать вопросы, задавайте их в микрофон, иначе у нас не будет перевода.
Okay. I have a question about Keynes theory.
Game theory, sure.
Yeah, and for me it's just, I can split this question in two parts. The first one about Keynes theory with relation with, in relation with labor market. How, on theoretical level, do you think this theory assesses it? And the second question about reality. How do you think this theory worked for some time, in some period in history, in relation with labor market? Is it affect labor market or it's... what do you think about that?
Right, okay, so this is a question about Keynes. Yeah, okay, Keynesian economics. What was Keynes basically saying? Keynes is really taking a macro view. Okay, so that's the first point to make. He's talking about the macro economy rather than the micro economy. He didn't really develop a theory of micro level relationships. He says something about labour, but he's really talking about labour at a macro level. Keynes argued that at a macro level, the system could break down under certain circumstances and not return to equilibrium because of underconsumption. Right. So, in other words, think about it this way. Firms must sell their products in order to be profitable. In a market economy, consumption of those products is essentially a function of the wages received by workers. Not completely. There are some people in a market economy who don't receive wages. They are paid from rents or from dividends or from profits, so they don't need high wages. A firm could just be producing for very wealthy people, that's true. But probably most firms cannot survive by just producing for those who live off dividends and rents. So the wage is, this is what Keynes says, the wage is a cost for the firm, but without the wage, the firm can't sell its products because there is no demand for the products. So this is a consumption problem, and Keynes also pointed to the difference between what's privately good for each enterprise and what's collectively good for all of them, the fallacy of composition. Right? The fallacy of composition basically means that something may be very good for each individual worker or each individual firm, but it would sum to a negative result. Now, each individual firm wants to cut its wages, wants to cut costs to be more profitable. But if they all do that, then no firms will be able to sell their products to labour in the end. Okay, they may export it, they may sell to rich people, but at the end of the day, they need workers to earn high wages in order to pay for the products the firms are making. Right. So Keynes said the reason for the Great Depression in the 1930s and so forth was underconsumption. And the solution was to increase pay and to make the pay hierarchy more equal, because if you give more money to poorer people, they spend more of it on goods. Right, so this is the difference between the marginal propensity to consume of poorer people and richer people. Richer people, on the whole, don't spend as much of their income as poorer people do. Right. They put it in the bank, or they're spending it on yachts or chandeliers. I know these days, increasingly, there are more ways for the rich to spend their money. It is true. Yes, you can read the Financial Times at the weekend and see there are ever cleverer ways to get rich people to spend their money and not put it in the bank. That's very important for a market economy. I understand that. However, if you redistribute down the income scale, you increase consumption because more of national income is being spent on consumption than on savings. Right. So Keynes argued for a number of things. The state should manage demand in the economy in a situation of a recession. when the economy is in the bottom part of the cycle, the state should spend money on infrastructure or other means to promote consumption. Some Keynesians, not Keynes himself, argued for collective bargaining to keep wages high. Right, okay. Keynes himself didn't say that, but other people did. Why did these theories fail? In the 1970s, there's very high inflation. And that's caused by many factors. Oil prices going up after the second Israeli-Arab War, the Yom Kippur War in 1973. Oil prices go up by 20 or 30%. Really, really big increase. Unemployment begins to go up at the same time. Right. The solution eventually was abandon Keynesian policies. Those policies worked in a period of low inflation. They didn't work in a period of high inflation. So instead of Keynes, we get, if I just get the right slide, go back to labour law and economic theory. This is, hang on, this is my Russian. That's it, isn't it? Friedman's theories. Yes. Friedman argued against the Keynesian position. And people began to argue that if the state, as Keynes argued, put money into the economy to promote demand, this wouldn't have the effect intended, because this goes back to rational choice. Workers and employers, if they saw the state artificially boosting demand, would rationally conclude that the effect of this would be to put inflation up. And so the impact of the state's intervention would be self-defeating. This is Lucas, rational expectations theory. So the reason Keynesian thought fell out of fashion was partly it wasn't really useful in a period of high inflation. The second reason was it became unfashionable in theoretical terms to think, in the way Keynes did, about the slow and incomplete way the market responded to signals. In the 1980s, it became fashionable to think that agents were fully rational, super rational, with rational expectations, and the best thing was to let the market work itself out rather than to have state intervention. And of course, collective bargaining is a kind of intervention as well, which is questionable if you believe people act with full rationality. Okay. So Keynes's ideas fell out of fashion in the 1970s. Maybe they're coming back into fashion now because today is a period of low inflation. So people talk about Keynes coming back into fashion. This hasn't really happened, okay? But Friedman and rational expectations have gone out of fashion. That's definitely the case. So you can see economic theory kind of goes in cycles. At the moment, we're waiting for a new Keynes or someone to really pull this together, I think. Yeah. I think you've got the microphone. Yeah.
First question just to add something. It's how do you think, is it such factor as outsourcing of labor market to abroad in the United States and from Europe? Is it influence to Keynes theory, maybe?
Okay, well, I think outsourcing is very important. I'm not sure about the link to Keynes, but clearly offshoring, outsourcing, globalization, they really put labour law under pressure, sure. And even outsourcing within a country is a way by which the employer gets more power over labour, that's for sure. So it reduces labour's bargaining power. So labour law today struggles because the firm itself is fragmented. The enterprise is fragmented. There's more subcontracting, more outsourcing, agency work. Okay. There's also offshoring, searching out low-cost labour. Now, it seems to me that the argument for globalization is that this process of outsourcing or offshoring ultimately levels up the conditions in developing countries with those in developed countries. I mean, that's a theory. Think about China today. If you go to the south of China, go to Guangdong, or one of these amazing cities with 20 million people in, Guangzhou, Foshan, Jiangmen, Shenzhen. Shenzhen was a fishing village. Yep. Now it's a city of 15 million people. Now, you could say, if it weren't for the ability of capital to move from the global north to the global south, and if it were not for free trade between the global north and the global south, this could never have happened. And it's not either fair or right to stop it happening. Right. Now, and then think about what's happening in China. We say China has undercut American producers, has taken jobs away from America. Maybe it did. I'm not sure it makes much sense to talk about a job as such being taken away in that sense. People have the right to make contracts or not. You could argue. But if you think it's just a one-way process, and of course it's very damaging for some parts of America and Europe that this did happen. It is damaging, and it's socially damaging, and maybe that's why we have the Brexit vote, or maybe it's why Donald Trump is so popular. That's what people are very much discussing. Okay, sure. Whether those things would have happened anyway is another question. Yeah. But if you think it just works one way, think about what's happening in China today. In China, wages are growing really fast, and labour laws are being implemented to protect workers against the worst features of exploitation. In 2007, China passed a major new labour law reform. And minimum wages in Guangzhou are now rising all the time. And yes, Chinese employers complain we can no longer be profitable. We need to relocate to Vietnam or Cambodia. But I can assure you there's also labour law reform in Vietnam and Cambodia. And eventually, where will capital go? Where will it go? Now, I've even heard people say in America, right, we need to cut wages to get jobs back from China, so we undercut China. Right. Okay. Now, the ILO exists to stop a race to the bottom. Okay. In my view, it also exists to promote development. Right. You can't say development is only for the global north. Development has to be for China, has to be for the global south as well. I'm of the opinion that this process doesn't mean the end of labour law. Right. Okay. As the global south develops, labour law becomes more important than ever. So if you want to know the country which has seen the biggest increase in the number of people covered by collective agreements ever, and the biggest increase in formal sector employment, formal contracts of employment, it's China in the last 20 years, bigger than anything which ever happened historically in Europe. Okay, but I'm getting ahead of myself here, but this is, yeah. Other questions? Yeah.
Yes, thank you, Professor. My name is Vladimir, and I have next question. Don't you think that the history of labor law is history of struggle of the weak side? I mean the workers. So if we let's see at Britain history of labor market. It's very similar with how to say similarities with consumers and producers in England, where their rights of consumers was not so protected till the very end of the 20th century in Britain. So the same with the workers. So not decades, but few centuries ago, England used even child labor.
Sure.
Yeah, and in 19th century, it's like it was impossible. And now labor in Britain is have high protection. So, do you agree that this labor market is part of history of struggle of weak side? It's struggle for human rights, firstly.
Yeah. So I'm not saying that labor laws emerge purely spontaneously. They have to be fought for, because employers resist them. people with power resist losing that power. Right. What I am suggesting, though, is that there's always been this tension between the need to organize the enterprise to make a profit and the need to protect society from the consequences of that system. It's always been there. And rather than it being a linear process of human rights improving over time, it's more cyclical, or a series of rising and falling degrees of protection for workers. Right. So you're quite right. Historically, in the early 19th century, in the Industrial Revolution in England, there was child labour, there were insanitary working conditions, very poor housing, discipline in the factory. Okay, so it looks as if the Industrial Revolution happened because all the controls were removed. That's one way of looking at it. Adam Smith's invisible hand had been allowed to function. Okay. But another way of looking at it is that actually in England, in the 18th century, there were the equivalents to social insurance. Some version of unemployment compensation, outdoor relief, some version of retirement allowances. There was already a national legislative framework for labour market mobility. Settlements, so-called rights to social insurance, were provided by legislation and enabled workers to move across the country from one job to another. This is completely characteristic of a world where workers had already lost access to the land. They had no guaranteed access to the land, and the family was not a support for them either. In England, in late Middle Ages, there was already no extended family. The nuclear family, the small family, has a long history in England. So my argument is not that labour law is inevitable or always works or just happens. It's got to be fought for. My argument is that industrialisation everywhere creates conditions which create a need for labour law, right, politically and economically. So you always see them in tension to some extent or another. And I think as long as there's a market economy, there'll be some need for labour or social security law in some form or another. The only economy where there's no need for labour law at all is the completely fictional perfect market economy. Right. Okay. Now, that model isn't a description of any world. Okay. It's a model used for generating claims we empirically test. We mustn't make the mistake of thinking that the perfect neoclassical model actually really exists. Okay. Historically, it never has. And whether it's useful for making predictions, we'll see shortly. Yeah. Does that answer your question?
In major part, yes. Okay. And I have maybe some additional part. You said very essential thing, that there are some inequality between the freedom of moving of capital and for free movement of labor.
Yes.
So, according to non-Holmes philosophy, it's like the main threat for each democratic society. Do you agree with this opinion or not?
Sorry, so this is Hobbes?
Non-Holmes. Chomsky.
Oh, Chomsky. Sorry,
yeah.
Sorry. Right. Okay, so Chomsky is... Chomsky is arguing exactly what? That this fundamental tension undermines democracy? Is that it?
Yeah, that inequality.
Oh, yeah,
inequality in economic area create inequality in political area.
Sure.
It means that no democracy.
Well, okay, so...
And misbalanced approach between free movement of capital and free movement of labor produce inequality in economic area, and after create inequality in political area.
Right. So, okay, so I guess the argument then would be that if you give rights to capital and you don't give rights to labour, there's this fundamental imbalance. Yes, obviously, I can see that. And so the question is, if capital is free to move across borders and workers are not, workers are placed at some sort of fundamental disadvantage. Now, okay, I guess you could say with globalization, it's really about free movement for capital. And this, to some degree, undermines workers' bargaining power. Maybe it does. Would the solution be to give complete free movement to labour? No. That might be also very destabilising for democracies. And probably nation-states can't function at all if there's complete free movement. Okay. Now, even in the European Union, right, we've had this big debate after Brexit, sure. Even under European Union law, there isn't complete free movement. Okay. There's free movement of persons for some purposes and free movement to look for work, but there's not a right, there isn't a right to claim unemployment benefit in another European country or other welfare payments in an unconditional way if you haven't been employed in that other country. If this simple fact about European law had been more clearly communicated to the British people in June, probably there would not have been a Brexit vote. But actually, the failure to communicate some basic facts about the European Union began a long time ago. Okay, so it's a long-standing problem. But the EU has the most liberal free movement regime for labour of any regional trading group, maybe in history. It is very, very liberal. And part of the argument is to offset some of capital's power. Can we reproduce that globally? No, I don't think you can reproduce complete free movement globally, because social insurance systems and other national institutions depend upon the principle of territoriality being respected to a certain extent. This is reality, you know. And the solution probably does lie in thinking a bit more about what free movement for capital means. Free movement for capital doesn't just mean you have a right to transfer assets from one jurisdiction to another. Increasingly, it came to mean capital is free to choose which laws apply to it. Right. That's often justified on the grounds that if legal systems have different rules attaching to capital, that's a barrier to free movement. Not in a formal sense, but in a sort of substantive sense. So you may argue, if there are different labour laws in force in the European Union, this has been argued, those more protective labour laws should be brought down to a common level to make it easier for capital to move to certain countries. Now, that seems to me to be a fantastically dangerous argument. You know, that's saying capital has the right to initiate a race to the bottom. And if that's what Chomsky is criticising, I agree with him. I'm not sure it is. I think maybe he has a different slant on this. But as a lawyer, okay, working in EU law and labour law, I think we need to very carefully think about what free movement for capital really means. And I don't think we can accept a situation in which capital has no constraints placed upon it at all in the name of free competition. I think that's a very slippery slope to set off on. At the end of the day, capital needs labour. So capital can move as far as it likes, but capital needs labour to make a profit. So that again is a constraint, even in a world of complete free movement for capital. Capital isn't in reality always very mobile. If you think about Toyota or Nissan, a huge Japanese car company invests in Britain, builds a massive factory. Okay, they're very unhappy about Brexit. Yeah, they are. They're not saying so much, although the Japanese government, you may remember, did write a 15-page memo, didn't it, to the British government at the time of the G8 summit. The Japanese government wrote a public letter to the British government saying, oh dear, we think you've made a big mistake with Brexit. Right, okay. The companies are too polite to say this, but they're really worried. Why is capital not completely mobile? If you go to Toyota's plant in the middle of England, in Derbyshire, it's like a little city. It's so big. They can't just move it. Right? They can't. Okay, they've got sunk costs. Yeah. So that's the reality. I mean, the reality is, at some level, capital isn't quite as free as people like to think, and also labour might be a bit freer, but that's not the answer to everything, I think. Yeah. Thank you.
First of all, thank you very much for a very interesting presentation. It was especially interesting for me as being a lawyer. And
Можно вас попросить представиться? Забыла с самого начала просить представляться.
Да, Сергей Кукс, бюро трудового права. And you presented some views of the Western economists on the labor law.
Yes.
It's very interesting, but I would like to ask you about something different. What is the influence of modern dominating economical theories on the labor law itself, on labor regulations? I don't know if you studied this way of interference and this way of influence. For example, I think that Russian labor law is still very much Marxist.
Interesting.
And the reason is simple, because it goes from Soviet labor law and it inherited some features and traditions. That's understandable.
Yeah.
But can you present some other examples of such influence?
Sure. Well, okay. I mean, I think we'll talk in the second half. Maybe we should have a pause in a moment.
That's great.
About Russia and about labour laws in different countries. I mean, I'll just show you though quickly. We'll come back to this chart. You can see not that one, this one. So the right hand graphic, I'll explain the methodology later, shows labour protection in different countries, and the higher the country on the scale, the more protective the law is. And you can see that Russia is about the most protective. Yeah. So that must be because of its legacy of Soviet law. Now, this is not the law in practice, though. This is just a formal law. Okay, so I'm not saying here that Russian labour law every day in the workplace is more protective than German or French labour law. What I'm saying is, you're right, I'm sure. The legacy of Soviet labour law inevitably must have some impact, although maybe not, it's not the only influence on today's Russian labour law. That's true. And it's also true that probably neoclassical economics has had a big influence on some other legal systems the opposite way. So if you look at the left-hand chart, you'll see America really does have very weak labour laws. Okay, now that's not just because of economic theory, but maybe it hasn't helped. And in Britain, you see the grey line. You go to 1980 on the left-hand. Okay. If you go to the grey line, 1980 in Britain, you see big decline. That's Mrs. Thatcher's government. And the Thatcher governments were very much influenced by economic ideas of Hayek and Friedman. So, sure, you clearly can see the influence of economic policy on labour law reform. You can also see the British line go up after 1997. So different theories, different economic models under New Labour, Tony Blair's government, to some degree changed policy back. So, yeah, I think there's a very strong sense in which labour law historically was conceived in terms of social justice. Increasingly, it's seen as affected by economic arguments. I think that's absolutely right.
Да, профессор Ловский. Лекция не закончена, но, конечно же, можно сказать вам большое спасибо за то, что мы услышали. Вопрос мой такой. Если немножко идти от теории к практическим вопросам, то у меня среди практических вопросов есть вот такой вопрос. В России 69 миллионов трудоспособного населения. А 20 миллионов работают нелегально. По вашему мнению, как можно изменить эту ситуацию, чтобы число людей, которые активно занимаются трудовой деятельностью, работало на легальной основе?
Yes, thank you very much. So it's a very important issue. Informal work, illegal work, and I think it's a huge issue in most countries around the world today. The terminology may differ, but the idea that labour law simply cannot reach some categories of workers, they're either working in unregistered firms, or they themselves are not in receipt of an employment contract. They may be described as informal or illegal because no tax is being paid. Informal work is a huge problem for labour law because labour law only really works on a regular formal employment contract of some sort or employment relationship. Without that foundation, it's very hard for labour law to work. Now, the causes of informality, what are they? Some economists would say labour law is causing informality because regulations may be too strict, too protective, firms can't observe them, right? There is some evidence for this in some countries, okay, but there are many other factors driving this, right? So what we're talking about with illegal work is often workers that don't have a regular wage, workers without a regular job, and firms unable to pay a regular wage. Right. Firms which are not sufficiently productive. In a sense, the problem of informality is unproductive capital as much as informal labour. And the solution to informality doesn't entirely lie within labour law. The solution to informality lies in the support the state chooses to give to smaller enterprises to become registered, to start paying tax. Also, of course, it implies that the state should not overtax smaller firms or overregulate them. Yeah, absolutely. But it seemed to me that the way labour law could help reduce informality is in conjunction with other policies that actually strengthen capital. People say this is ironic. How can labour law be in favour of strengthening capital? Well, labour law is in some senses about making capital more productive. Right? Labour law is about reducing transaction costs, facilitating exchange, giving both firms and workers incentives to invest in human capital. Now, labour law is also about fairness and social justice. I don't want to suggest it's just about efficiency. But I don't believe that justice and efficiency always oppose each other. Right? I think the task of the labour lawyer really is to find some sort of reconciliation between them. Now, I haven't studied the Russian labour market. I have studied other informal labour markets in China, and most recently, last week I was in Peru, and we had a very interesting discussion about informality in Latin American labour markets. One very striking phenomenon is that as economies become market economies, and as they grow, informality tends to go down. And it may take a very long time, but informality in China is going down, informality in Peru is going down, informality in South Africa is going down. Okay, so partly the solution lies in economic growth, and many, many factors contribute to economic growth. Labour law can't do everything, but I fully agree with you that it's a really big issue for labour law, and we have to find ways to deal with it. Yeah.
Ну, у нас, наверное, закончились вопросы по первой части. Я хочу с вами посоветоваться. Мы сделаем перерыв. Нужен перерыв, да? Хорошо, давайте тогда сейчас Do we need a break?
I think so, yes.
Yeah. Давайте тогда сейчас сделаем перерыв. Кто остается с нами, тот остается. Я понимаю, что, наверное, кто-то пойдет домой. Ну, и через 10 минут примерно здесь же встретимся для продолжения. Спасибо.
Good.